Actually, can I just clarify, because I'm not sure I understand? Sort of looking at this from a broader perspective, it seems to me that EMTALA says you must provide whatever treatment you have the capacity, meaning staff and facilities, to provide to stabilize patients who are experiencing emergency medical conditions. Idaho law seems to say you cannot provide that treatment unless doing so is necessary to prevent a patient's death to the extent the treatment involves abortion. Why is that not a direct conflict? You must in a certain situation, that's what the federal government is saying, and you cannot if it involves abortion, says Idaho.
I think the nurse example really highlights the reason why. Because a nurse might be available. The nurse may even think she knows how to. And under the flat must provision in EMTALA, the administration's reading would say, call her into action, put her into the operating room, and open the patient up. But
right.
that is
and Idaho would say, no, that's still a conflict. So fine, let's say the administration's position is that nurse can do it. Are you suggesting that federal law would not take precedence, would not preempt a state law that says, no, she can't?
Well, whether federal law could do that is a different question than whether EMTALA here does do that. And I think the answer is clear that it doesn't. I mean, it's like the Gonzalez v. Oregon case where the Controlled Substances Act, this court noted that was the provisions there rely upon and assume a medical profession being regulated by state police powers. That's the same with EMTALA. EMTALA is a 4-page statute. Congress didn't attempt to address the standards of care for every conceivable medical treatment.
It definitely didn't address the standards of care. It did leave that to the medical community. It said, Congress was not going to address every treatment for every condition. But it said you do what is needed to assure non-deterioration. So I guess the question here is, do you concede that with respect to certain medical conditions, an abortion is the standard of care?
No, because the standard of care in Idaho, there's a life-saving exception for certain abortions, and that is the standard of care. And the standard of care is necessarily set and determined by state.
Well, I think you have to concede that with respect to certain medical conditions, abortion is the standard of care because your own statute, as interpreted by your own courts, acknowledges that when a condition gets bad enough such that the woman's life is in peril, then the doctors are supposed to give abortions. And the reason that that's true is that with respect to certain rare but extremely obviously important conditions and circumstances, abortion is the accepted medical standard of care. Isn't that right?
Yes, and that was my point, that there is a life-saving exception under Idaho law. Now, the question here is...
Now the question is it also the accepted standard of care when, rather than the woman's life being in peril, the woman's health is in peril? So let's take, all of these cases are rare, but within these rare cases, there's a significant number where the woman is, her life is not in peril, but she's going to lose her reproductive organs. She's going to lose the ability to have children in the future, unless an abortion takes place. Now, that's the category of cases in which EMTALA says, my gosh, of course the abortion is necessary to assure that no material deterioration occurs. And yet Idaho says, sorry, no abortion here. And the result is that these patients are now helicoptered out of state.
Yeah. Your Honor, the hypothetical you raise is a very difficult situation. And these situations, nobody's arguing that they don't raise tough medical questions that implicate deeply theological and moral questions. And Idaho, like 22 other states, and even Congress and EMTALA, recognizes that there are two patients to consider in those circumstances. And the two-patient scenario is tough when you have these competing interests.
That would be a good response if federal law did not take a position on what you characterize as a tough question. But federal law does take a position on that question. It says that you don't have to wait until the person is on the verge of death. If the woman is going to lose her reproductive organs, that's enough to trigger this duty on the part of the hospital to stabilize the patient. And the way to stabilize patients in these circumstances, all doctors agree.
There is a difference between stabilizing a person who presents a serious medical condition requiring stabilization than a person who presents with a condition, quoting Idaho's words, where there is poses a great risk of death to the pregnant women. You agree there's daylight between the two?
We agree, and I think this is
and so there will be some women who present serious medical condition that the federal law would require to be treated who will not be treated under Idaho law.
No, I disagree with that. Idaho hospitals are treating these women. They're not treating these women with abortions necessarily, Your Honor. And that's an important point.
Just answer the point, which is they will present with a serious medical condition that doctors in good faith can't say will present death, but will present potential loss of life. Those doctors, potential loss of an organ or serious medical complications for the woman, they can't perform those abortions.
Yeah. Your Honor, if that hypothetical exists, and I don't know of a condition that is so certain to result in the loss of an organ, but also so certain not to transpire with death, if that condition exists, yes, Idaho law does say that abortions in that case aren't allowed. And I think
all right, let me stop you there, because all of your legal theories rely on us holding that federal law cannot preempt state law on these issues. And so when I asked you the question, if a state defines likelihood of death more stringently than Idaho does, you would say there's no federal law that would prohibit them from doing that.
Well, I would say that EMTALA does not contain a standard of...
So there is no standard of care. In your briefing, you made the SG's position here, and you almost argue that now, that their position that federal law requires stabilizing treatment and not equal treatment of patients, which was a position you took in your brief. You seem to have backed off from it here. You seem to agree that federal law requires some stabilizing condition, whether or not you provide it to other patients. But I have countless briefs that say that HHS has filed that pre-Dobbs, pre-2009, this is not an unprecedented position, that HHS in countless situations cited hospitals for discharging patients who required an abortion as a stabilizing treatment. Congress discussed that topic in the Affordable Care Act and explicitly said that nothing in the Affordable Care Act shall be construed to relieve any health care provider from providing emergency services as required by state or federal law. Medical providers have told us that for decades they have understood both federal law and state law to require abortions as stabilizing conditions for people presenting serious medical risk. Lower courts, there's at least cases of lower courts saying you have to provide abortion. So this is not a post-Dobbs unprecedented position by the government.
It absolutely is. In footnote 2, the administration cites to two spreadsheets that contain 115,000 rows of enforcement instances. The administration has not identified a single instance.
Counsel, pre-Dobbs, this wasn't much of a question, but there is HHS guidance, and there's at least 3 cases in which it was invoked. The fact that that HHS didn't have to do it much before pre-Dobbs doesn't make their position My point
is more fundamental, Your Honor. It's not just that there are few instances. There are no instances, and not just on the issue of abortion. On any instance where HHS has come in and told a hospital, you have to provide a treatment that is contrary to state law. And this isn't just about abortion. Consider opioids.
Now we're back to that. Okay. Thank you.
Mr. Turner, practicing medicine is hard, but there are standards of care, aren't there?
Yes, there are.
And one of those standards of care with respect to abortion is that in certain tragic circumstances, as you yourself, as your own state's law acknowledges, where a woman's life is in peril and abortion is the appropriate standard of care. Isn't that right?
That's right.
And EMTALA goes further. It says that the appropriate standard of care can't only be about protecting a woman's life. It also has to be about protecting a woman's health. That's what EMTALA says, doesn't it?
No, it doesn't. It defines emergency medical condition with a broader set of triggering conditions, but the key question here is what is the stabilization requirement, and that is qualified by the availability term.
The stabilization requirement is written in terms of making sure that a transfer would not result in a material deterioration as to the emergency condition. Nothing about has to be at death's door, right?
I think that's right, yeah.
And there is a standard of care with respect to that on abortions too, right? If a woman is going to lose her reproductive organs unless she has an abortion, which happens in certain tragic circumstances, a doctor is supposed to provide an abortion. Isn't that right?
EMTALA doesn't contain any standard of care. I don't know where the administration is
Do you dispute that there's a medical standard of care that when a woman is about to lose her reproductive organs unless she has an abortion, that doctors would not say that an abortion is the appropriate standard of care in that situation?
Your Honor, what I dispute is that there is a national uniform standard of care that requires a top-down approach in all states. Idaho has set its own standard of care, and it has drawn the line on a difficult question. And it's inconceivable to me to think that Congress attempted to answer this very fraught, complicated question in four pages of the U.S. Code. It did not.
Congress said, as to any condition in the world, if an emergency patient comes in, you're supposed to provide the emergency care that will ensure that that patient does not see a material deterioration in their health.
And always
That's what Congress said. And the abortion exceptionalism here is on the part of the state, saying we're going to accept that with respect to every other condition, but not with respect to abortion.
Abortion isn't
where
exceptional.
We will not comply with the standard of care that doctors have accepted.
Your Honor, abortion isn't exceptional. There are numerous cases where states intervene and say the standard of care in this circumstance for this condition is X, not Y. Opioids, for example. In New Jersey, a doctor cannot stabilize chronic pain with more than a 5-day supply of opioids. In Pennsylvania, it can be 7. In other states, there's no limit. Their reading of EMTALA requires that those limitations get wiped out and you impose a national standard. There are numerous other instances where states are coming in and saying, in our state, the practice of medicine must conform to this standard. And Idaho has done that with abortion. It's done it with opioids. It's done it with marijuana use. There are countless examples, Your Honor.
And your theory, although the Supreme Court has narrowed the reach of your statute, your theory would apply even if it hadn't. I mean, it would apply to ectopic pregnancies. It would apply even if there were not a death exception. I mean, all of your theory would apply no matter what, really, Idaho did, wouldn't it?
Yeah, I think the answer is EMTALA doesn't speak to that, but there are other background principles and limitations like rational basis review, Justice Rehnquist, the Chief Justice
But your theory of EMTALA is that EMTALA preempts none of it, that a state tomorrow could say even if death is around the corner. A state tomorrow could say even if there's an ectopic pregnancy, that still that's a choice of the state, and EMTALA has nothing to say about it.
And that understanding is a humble one with respect to the federalism role of states as the primary care providers for their citizens, not the federal government.
It may be too humble for women's health, you know? Okay, thank you.